The state has an interest in promoting patriotism and national unity. But how far can the government go? Can it require someone to speak in a way that violates his or her conscience or religious beliefs? In 1943, America was fighting World War II. In West Virginia, school children were required to pledge allegiance to the American flag every day to show their patriotism. Students who failed to comply could be expelled. William Barnette and other Jehovah's Witnesses challenged this requirement on behalf of their children. For Jehovah's Witnesses, they explained, the flag was a graven image. Pledging allegiance to it would be a form of idolatry forbidden by their religion. The Jehovah's Witnesses argued that the pledge requirement violated their First Amendment free speech and free exercise rights, as incorporated against the states by the 14th Amendment. They took their fight all the way to the Supreme Court in a case called West Virginia State Board of Education versus Barnette. The State Board of Education argued that the government had authority to foster national solidarity in wartime. The board relied on a Supreme Court decision from only 3 years prior. In Minersville School District versus Gobitis, the justices had ruled 8-1 that a mandatory pledge did not infringe on the free exercise rights of Jehovah's Witnesses. Gobitis had held that the state had a compelling interest in promoting national unity, and the court should not interfere with local educational policy. In a 6-3 decision in the Barnette's case, the Supreme Court overruled Gobitis. Writing for the majority, Justice Robert Jackson held that government could not force individuals to declare beliefs they didn't hold, at least in the absence of a grave and immediate danger to legitimate state interests. But the state had no legitimate interest in coercing uniformity of opinion. Justice Jackson wrote, quote, "If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein." Overruling an 8-1 decision from only 3 years before was unusual, but the court's composition had changed. Also, Gobitis had resulted in widespread and sometimes violent harassment of Jehovah's Witnesses, which shocked the justices and public opinion. Justice Jackson viewed Barnette as a free speech case. The fact that religion motivated the Jehovah's Witnesses was not relevant for him. But 3 justices who concurred in his opinion wrote separately to emphasize that for them, Barnette was a free exercise case. Free speech and free exercise rights often overlap, and judges continue to puzzle over how best to distinguish them. The court continues to cite Barnette today, in ways some find controversial. In 2023, the court relied in part on Barnette to rule that a state could not compel a commercial website designer to express messages with which she disagreed. Some commentators argue Barnette shouldn't apply in the commercial context. Nevertheless, Barnette represents a defining moment in constitutional law. Even during wartime, the justices held, the state lacked authority to coerce public expressions of citizens' loyalty and beliefs. The decision reminds us that patriotism flourishes more readily through voluntary expression than coercion, and that religious liberty and free speech are essential to our democracy.